Assalamualaikum and good day to everyone. We are from Group 6. We'll be presenting in regards to our discussion for assignment 2. Hope you enjoy and gain something from it. Thank you. Question 3. Explain the conditions for the application of Cyprus. Cyprus is a doctrine where a charitable trust that at the initial stage proved impossible or impracticable or becomes so subsequently may not fail if the court can apply the property to some other charitable purposes as nearly as possible to the originally intended. According to the book titled Pengenalan Undang-Undang Amanah Malaysia in year 2000, to apply the Cyprus doctrine to a failed charitable trust, the court will look at the intention of the settler, which must be towards a general charitable purpose. If the intention of the settler is towards a specific charitable purpose and it is impossible to execute it, the Cyprus doctrine cannot be applied and the gift fails completely. Therefore, from the discussion earlier, we could convey that there are two conditions to apply the doctrine of Cyprus, which is firstly, the impossible or impracticability to perform the original charitable trust, and secondly is general charitable intention, where the settler must show paramount intention for charity.
So the first condition to apply the doctrine of Cyprus is the impossibility or impracticability to perform. So the impossibility question on whether the purpose as stated by the settler could be accomplished rather than simply being undesired. This principle had been illustrated in the case of Redominion Students' Hall Trust, where in this case, the object declared is to maintain a hostels for students of European origin from overseas dominion of British Empire. So to get the approval by the court, the company had schemes that the word of European origin would be deleted so that the company would be better equipped to administer the funds for the benefit of all students from the dominions regardless of racial origin. So it was held by the court the word impossible should be given a wide significance. So if they retain the word, it may undermine the charity's primary purpose and it can be said to fall within the broad description of impossibilities. There are two circumstances under the impossibility or impracticability to perform, which one of it is the initial impossibilities. So the initial impossibilities is said to be occurred when, first, the property given to charity ceased to exist on the date the gift took effect, and second, the charitable organization existed on the date when the gift was made, however, ceased to exist on the date it was executed. So, if these initial impossibilities occurred, the court may apply the doctrine of Cyprus. However, this doctrine will only be applicable if the court finds that there is a general charitable intention. There are few situations where the initial impossibilities had been occurred. So, the first one is the failure of gift to specific named charitable body. So this has been illustrated in the case of Reimer in 1984, where in this case, there was a donation of $5,000 to the rector for the time being of St. Thomas Seminary for the formation of prayers for the Diocese of Westminster. At the time the testatus died, the seminary had ceased to exist and the student had been transferred to another seminary in Birmingham. So, based on the intention of the donor, it was a gift to a particular seminary. So, there was no general charitable intent and therefore Cyprus cannot be applied. So, the second situation where the initial impossibilities is said to be occurred when the gift is for the non-existent institution. So, we can take a look in this case of Hartwood in 1936, where there was a donation left for a number of institutions, including the Wisbech Peace Society and the Peace Society of Belfast. So the first gift is said to be failed because the Wisbech Peace Society had ceased to exist at the time of the testator's death. However, there was no evidence showed that the Peace Society of Belfast had ever existed during that time. So it was held by the court that for the Peace Society of Belfast, there was a general charitable intention as the donors had desired to benefit any society in Belfast. So there was a paramount charitable institution to benefit any society that was formed for the purpose of promoting peace and was connected to Belfast. So the third situation where the initial impossibilities is said to be occurred is when the gift is for the institution which have been amalgamated or reorganized. So we can take a look in the case of Rifaraka in 1912, where in this case there was a gift for Mrs. Bailey's Charity Rotary, which did not exist as independent bodies. However, it did not fail because it was an amalgamated with other charities with the same purpose to benefit the poor of Rotary. So the judgment by the Court of Appeal is that there was no need to apply the cypress since the original charity is still continue to exist in an amalgamated form. So it was important to note that if the gift is to a charity which has been consolidated with other charities with the same purpose under the same scheme, the gift did not fail because the charity was still in existence. Only the missionary of the charity had been changed. The next situation is the charity by association. It had been illustrated under the case Resettlewaite's Will Trust, where in this case, the settler had left all her estate in equal share to 9 animal societies which she had randomly choose in the telephone directory. So one of the animal societies, named as London Animal Hospital, had ceased before the settler had even made her will. So based on the judgment, on the evidence, the bequest was a gift by descriptive title to benefit a purpose and not a person or individual. So it was said that she had the general charitable intention in favor of a charity through the medium of kindness to animals. The last situation is the surplus fine, where it was illustrated in the case of Free King in 1923. So in this case, the money was specifically designated for the installation and maintenance of the stained glass memorial window in a church at Chester that resulted in a surplus. So in this case, the court held that the cypress was applied for the installation of similar windows in the church.
Next, I will continue on supervening impossibility, which occurs when the trust becomes impossible to perform due to the happening of some unforeseen circumstances which were beyond the control or calculation of the parties involved. It is a condition whereby impracticability and impossibility arise after trust has been created. The rule is that once a charity is established, it is not allowed to fail as the property has been given out to charity. Thus, the gift cannot fail because it has already been taken effect. Next, under the supervening impossibility, the general rule is this: once charitable, always charitable. Where a gift is made to a charitable body, which exists at the time when the gift vested, but subsequently it ceases to exist, there is no need to show a general charitable intention on the part of the settler. If the charitable body subsequently ceases to exist, then any remaining property can be applied cypress. This means that it is already sufficient if the property was given absolutely and perpetually to a charity. There is no need to look at the charitable intention, as in the past the trust was operative. The case that can be referred to is the case of Rees-Levin 1891. In this case, the testator left legacy of £200 to the orphanage of St. Dominic's, Newcastle, which was a charitable institution that was in existence at his death, but it ceased to exist before the legacy was actually paid. The court in this case held that the gift could be applied cypress. This is because the charity acquired the equitable right to receive the legacy on the testator's death. The second case is the case of Attorney General against Lim Poh Neo and others. In this case, a subject matter of a gift, which is a piece of land, was acquired by government for military purposes, and thus it became impossible to carry out the gift. In this case, the court held that cypress was ordered since the settler had intended to make out and out gift of the property for charity.
The court also held that a gift for a burial ground to a clan was a good charitable gift. So from this case, the effect is that it enables trust property to be used for other purposes which resembles the donor's original purpose. Moving on to the next one. One example of Malaysian case involving supervening impossibility is the case of Tai Kian Luing against Teh Po San 1961. In this case, the settler established a charitable trust upon the terms and for the express purposes contained in the trust deed. The first part of the trust provided for a named school and hospital in Penang. The second part provided for named school and hospitals in specified places in China, and the deed further provided that in the event of there being any other new schools or hospital in the aforesaid places in China being subsequently opened, the head trustee shall have full discretion and authority to include the same amongst the above. In this case, the question arose as to whether the second part of the trust was void for impossibility of performance, and if it was, whether there was a general charitable intention on the part of the settler to devote this part of the property for charitable purposes generally. So, for this case, it was held that the mere fact that the government of this country does not recognize the government of Communist China could not make the trust void for impossibility of performance. The sole question is on the practicability or otherwise of administering the trust fund. In the light of the evidence before the court, it could not be said that the trust was void for impossibility. Thus, the court decided that there was a good charitable trust. Whether it might subsequently lapse by reason of impossibility of performance depended entirely on whether the controller of foreign exchange would be prepared to sanction the application made by the trustee of the deed to remit monies arising out of the trust fund to the specified institutions in China. Thus, to sum up our discussion on the supervening impossibility, it can be said that it is a circumstance where the charitable trust becomes impossible, whereby its continuance is not subjected to the existence of a paramount charitable intention, as what matters is the property which has been given out and out to charity in the sense that the donor did not envisage its return in any circumstances. With that, my part ends here and I will pass to the next presenter.
Moving on to the next condition under Cyprus, which is the general charitable intention. Basically, a general charitable intention can be said to be a paramount intention on the part of the donor to effect some charitable purpose which the court can find a method of putting into operation. So when we talk about general charitable intention, we shall look into two circumstances, which is the initial impossibilities and also the subsequent impossibilities. For the initial impossibilities, the general charitable intention is required. Meanwhile, for the subsequent impossibility, the general charitable intention is not necessarily required. First of all, we shall look into the situation in which the general charitable intention is present under the initial impossibilities. So we shall look into the case of Anthony General versus Lim Po Nyo, in which, in this case, the Anthony General on the relation of interested party of the Hokkien tribe of the Yo clan has commenced the suit as plaintiff and claim against the trustee due execution of the trust settlement and an account of the money received by them as trustee, which is in particular the money received as compensation awarded as a result of the government acquisition of the said land. So in this case, the issue is whether a scheme of Cyprus should be directed in respect of the money from the acquisition of the land, and it was held that it was a gift of a burial ground to a clan was a good charitable gift, and there were charitable intention. In these circumstances, the gift fell due to the government acquisition of the land, and the proceed of the acquisition was held to be Cyprus. Next, we shall look into the situation in which there is lack of general charitable intention. One of the landmark cases that we can look into is the case of Revolson, in which, in this case, when a testator passed away in 1870, the testator has left a sum of money as a salary for a schoolmaster who is to teach at a school that will be built with the help of voluntary contribution from landowners nearby the neighborhood. However, the school was not likely to be built. Therefore, in this case, it was held that the element of general charitable intention could not be established, and therefore the Cyprus doctrine could not be applied.
Therefore, we can conclude that respect for the express intent of the truster and the need to maintain efficiency of charitable trusts are legitimate interests that often conflict, which requires the legal system to strike an appropriate balance between them. Therefore, the expansion of the doctrine of Cyprus to accommodate changes that are necessary for the sake of efficiency and an alteration of court's basic approach to petitions for the doctrine's application would correct the imbalance and relax the sometimes unjustifiable control of the dead hand without defeating the sound policies behind difference to trusted intention. That's all from us. Thank you.